Welcome to Court Helicopter Explainer, which is on the question of land. Do you know you can own land for 60 years and yet you can lose that land through a principle called adverse possession? We've dealt with this question of adverse possession, but today we want to give you the case, the facts from a case in the Court of Appeal, Nyeri, so that you can understand that you can lose your land. You can have your title deed and you can lose your land. The fact that you have land, you can lose your land. Let me not give you the sugar in this case. It's a very interesting matter. In the Court of Appeal in Nyeri, the judges are Justice Kantai, Justice Mumbi Ngugi, and Justice Ali Abida Aroni. All of them are judges of the Court of Appeal. This is the civil appeal number E029 of 2021. This matter was between Ishmael Joram and Ephantaz Murevi Obadiah. So the question here, and I want to read, this is a matter that went to the lower court, the high court. And the party that lost in the high court went to the Court of Appeal on the question of adverse possession. Listen so that you get it. The late Obadiah's case was that he bought the suit property from Joram and Ishmael sometimes in 1961. And he paid 1,000 shillings out of the agreed purchase price of 1,350. So he paid 1,000, he remained a balance of 350 in 1961. And he took possession of the land immediately. However, he stated that the consent of the Land Control Board was not obtained and the transfer process was never concluded because the Land Control Act had not yet been enacted. So, and this one we have always told you, when you buy any agricultural land, the person selling you the land must take you to the Land Control Board to get the consent. He's the owner, but he must get consent from the Land Control Board to sell the land. He's the owner, he must get the Land Control Board consent to divide the land. He's the owner, he must get Land Control Board from his family. Because here is where mothers, wives, children come and say, Daddy is going to sell this land. Tutaenda wapi? The Land Control Board consent is very, very critical. He goes on to say, Obadiah said that he had occupied the suit land for more than 16 years and ought to be registered as the owner of the virtue of adverse possession. He said, and this is now where issues start. Obadiah said he entered the suit property when it was a bush, but had undertaken extensive developments of the land and planted coffee bushes on the land. On the other hand, the appellant, the owner, the actual person with the title deed, is arguing that his case was that he had been allocated the suit property by his clan in 1960. But he did not utilize it as he was working in Nairobi. Are you working in the US? Are you in the diaspora? You were given land, you bought land, but you are not going there because you are elsewhere. Do you have land in the village, but you are in Nairobi? You've never gone to dig that land. Listen. He said that he did not know when did Obadiah settle on the suit property, as he was not around. But he asked his father to tell Obadiah to leave that land. When he knew, he told his father, hey, Daddy, ambia huyu mtu Obadiah atoke kwa shamba yangu. He considered that there were some houses built on his land. There were some coffee and tea bushes on the property. You can now understand. He moves on to say, he argued that there was no, he proceeded to say his case was one of adverse possession, where he claimed that he quietly and peacefully and without any resistance entered the suit property in 1960 and continued in occupation and possession of the same, that he had developed the suit property where he lived with his family, constructed houses and planted crops for more than 12 years. Obadiah is saying he entered the land in 1960. He has planted coffee, he has planted tea, he has built houses for over 12 years. So this is my land. Let us look at what he says. He goes on to say, a look at the record of appeal shows that the appellant testified and told the court that he worked in Nairobi from 1961 and used to visit the land occasionally and that it was empty. He reportedly only discovered in 1974, very clear mark, since 1961. In 1974, he discovered that the land had been occupied by Obadiah, who settled on it. Throughout the record, the recurring theme is that he did not have any permission to occupy the suit property. In his grounds of appeal, the appellant claims that the court ignored that. We note that the appellant told the court that he first saw a hut, ile kanyumba kale ka nyasi, a hut on the suit property in 1974, and told his father to ask Obadiah to leave the property. It seems he did not take any further action until when he wrote a demand letter dated 8th July 2002 complaining about trespass. Have you seen somebody has put up a house, a property in your house, a toilet in your land? When you go to a lawyer who writes a demand letter, that demand letter will not save you, my brother. The demand letter was complaining about trespass. He filed a matter, PMCC number 463 of 1993. However, this case he filed was seeking for damages of destruction of trees, and he did not attempt to evict the owner of the said hut, which he had observed in 1974. He goes, he admitted in cross-examination that there were houses on the land, coffee and tea bushes. Yet he himself was not the owner of those houses. The person who put there told the court during his testimony that his wife and 3 children are buried on the suit property, which evidence was not disputed. My friend, this person came, built a hut, 1974. He built houses. He married his wife. 3 children have died. They have been buried there. The owner is in Nairobi. The owner is in UK. The owner is in Sydney. The owner is in Australia. Wow. The graves are there. What did the judges do? In our considered view, none of the actions of this person interrupted the possession of the suit property by the respondent. Verbal warnings, demand letters, and suit for costs of damages cannot be said to have interrupted the use of the land by the respondent. This one is what we call adverse possession. What are the parameters the judges set for them to see? For one to succeed in a claim for adverse possession, one must prove and demonstrate that he has occupied the land openly, number one. 2, that it is not without force. He never came into the land by goons. 3, he never hid without secrecy. He has been there, not the person who comes at night and goes away during the day. He has been there, and not with a license or permission of the landowner. He is not there because the landowner has allowed him to be there. There must be apparent dispossession of the land from the loan. In essence, a party claiming adverse possession has to prove that they have occupied the land in question openly without license or permission of the landowner, with the intention to have the land, and that they have dispossessed the registered owner of the suit property for the statutory period of 12 years. That is the condition. So, what did the judges do? We therefore find that the ELC judge rightly considered the evidence and the facts, and rightly held that the respondent proved the claim of adverse possession against the suit property, while the appellant did not assert his rights over the suit property. Our conclusion is that this appeal is unmerited and is dismissed with costs, dated and delivered in Nyeri on the 25th day of March 2026. S. Ole Kantai, Judge of the Appeal Court; Mumbi Ngugi, Judge of the Appeal Court; Ali Aron, Judge of the Appeal Court. I certify that this is the true copy of the original signed by the Deputy Registrar. What are the lessons in this matter? A man with a title deed bought land 1960. He went working. He discovered in 1974 that somebody has put a grass thatched structure. He told his father, tell him to go away. Later he wrote letters demanding the guy to leave for trespass. Later he went to court. The judges have said, if you do not occupy your land and somebody occupies your land for 12 consecutive years with your knowledge and you do nothing, you have never gone there and you don't evict that person, he will go to court under adverse possession and he will be given your land. Imagine. People in the diaspora. Is the land you bought in Kitengela? Is the land you bought in Kisii? Is the land you bought in Ukambani, Machakos? The land you bought in Naivasha? Anywhere in this country? Are you going to lose it by adverse possession? Yes. If you are not careful. Wakili Dan Sanomari brings to you a landmark Court of Appeal decision. If you do not assert your rights over your land, if you sit like this friend of ours who was busy working in Nairobi for his employer and forgot to go and take care. Now you understand why every Friday, every Saturday, people drive home. People go to supervise the land. The judges are funny. The judges are giving a very old concept of taking possession of the land. He says, in the case of Joseph Gashubi Kiritu versus Lawrence Munyambu Kaburu, 1996, time which has begun to run under the Act is stopped either when the owner asserts his right or when his right is admitted by the adverse possessor. You must put that time. If this man has been on your land for 5 years, you must go and stop the time running. If you keep quiet and the time starts running from when this person entered your land, how do you stop the time running? Assertion of rights occurs when the owner takes legal proceedings or makes legal proceedings. You must file a case in court to evict that person. If you don't file a case in the ELC court, you are wasting your time. Demand letters are useless. 3, or make an effective entry into the land. You must go and enter into the land. The reason why every time I've said people travel home to wanazunguka where they are bought land, that is entry. You will be recording nowadays on your phone. I was here on my land on this date. Keep that as a record. Do you have a record when you went to visit the land you bought? You have a smartphone. Wakili Dancer Numari is advising you. Keep records how many times you have gone around the land you bought or the land that you have. You'll produce in court that if the man was there, I was there 2 years ago. This is the evidence. I was there after 6 months. This is the evidence. That is what you call asserting that you have entered victoriously. He moves on. The old rule was that a mere formal entry was sufficient to vest possession in the true owner and to prevent time from running against him. That is it. If you enter that land, the time stops running. But if you have never entered that land, time is running. He must therefore make a peaceable and effective entry or sue for recovery of the land. So the judges are telling you, ukilalia masikio, ukilalia right yako, you come to cry later. This man, he bought land. The land was bought in 1960. He was given that land in 1961. He lost that land. The land was bought at 1,350 in 1961. What is the price of that land now? It is over 16 billion if he had that land to sell. So the land you bought and you've left for adverse possession, what you spent, the fortune you spent, can go to waste. You'll go crying, as the late Whispers Mutai said, Nima korera kioro. They will go crying in the toilet. Nobody will help you. You know the law? Go and make sure any land that you have bought, if you have 10 pieces of land, make sure yearly you make a visit to all those lands and you assert authority over those lands. Wakili Dan Sanomari, being a pleasure to bring to you the law as it is. Keep watching. We bring you the law. We avoid emotions. We tell you, don't cry in the toilet. Emotions don't help. Assert your right over a land that you bought so that you don't lose your land for adverse possession. Thank you very much.